Humans as a species have a right to grow. We always have. We want to grow forward. We want to get better. We set goals. We achieve them. We want to move forward. The same applies to individuals who have come in the UK on skilled worker visas. This is Sachin Sawant, your UK immigration lawyer. Today I'm going to talk about skilled worker visas and doing your own business, registering your own business. I have been asked these questions in many consultations I have done. Every time it is very case specific. There is no blanket answer, there is no yes and no to it. I'll just try to open up various areas, various aspects where this may interfere or enter, or how to go about these things. So, and you decide for yourself. I'll just touch on various aspects that you should be cautious about. First and very important thing, on your skilled worker visa, you should have contracted hours. So let's say you are contracted for 36 hours a week. For your business, whatever that is, first I'll take get out the easier option. So if you're passively investing, there is nothing in the immigration rules telling you yes or no on that. So no one can tell you 100% yes, this is possible, this is not. This is just from experience and how things are viewed from the home office perspective, what is usually allowed, what is considered as not allowed. So overall, so registering a business, and let's say it's just a passive business, you ended up registering it. I know many times students tell you're not allowed to do it. Yes, technically speaking, you should just go and cancel. That will be one of the things if you're a student and you're trying to do it. But let me focus today on the skilled workers. So skilled workers always they want to grow forward and they want to set up their own businesses, etc. So if you are on a skilled worker, you have contracted hours. One of the important things that you need to be able to justify it if you do register a business. First thing, if it's just a passive name, so if you're just registered as a passive director and you are not doing much, I know I've been asked by clients if I am a director of a housing association. I know you don't do much, you're just on the, it's quite a namesake directory, and once in a while you'll just do something for 30 minutes. That's it. Not much. I don't think they do that much. So that such things would be allowed where you are passively just holding a directorship or something, some type of ownership in the company. Secondly, any investments, all this is not in the immigration rules. This is just out of practice, what Home Office may perceive as working, additional work, allowed, not allowed. So, in my opinion, passive working, passive investments, if you're just registered as a director, I don't think that much it would matter. If you just registered a business, that would also not matter. But if you are registering a business without any reason, I would rather say don't register it. Or if you already registered and you're not doing anything on it, rather just close it down. So that would be a better explanation. I registered, I asked an immigration advisor, and then I decided to close it because I was advised I cannot do work per se. So the working aspect is when the game changes a lot. Just registering the business, let's say you are just buying shares of a company, you're not doing anything, you're just a shareholder. That is not stop, that is just passive investment. So first one was, say, passive directorship. That would be okay. Passive investment, holding bonds, debentures, shares, whatever that is. And so I don't think that would be taken as anything against you are not complying with your skilled worker requirements. But yes, if you are starting a business, you started generating revenue, the questions that may come is at the point of either extension or ILR. Because what will happen on your NI number, definitely the searches will come, your incomes will be reported, somewhere something will connect, your bank account number, your NIs, your taxes paid on that business, etc. Anything and everything. And if something is seen by the Home Office as to this person has been given a skilled worker visa, yes, he is doing that, okay, fine, we have all the payrolls and everything run, but at the same time we have some other incomes coming through. What is it about? That is just a curiosity that would start the game. So it's not necessary that every caseworker would do it, but nowadays HMRC UKVI has a portal with HMRC. They can just put your INI number and they can just search everything from the HMRC side, from your whatever numbers you have for the business also. So it's very easy for them. It may take just 2 minutes or 5 minutes just to do a search and find what is there. And with skilled worker applications, they do have time to do all those searches because there is not much to check. in extensions or even ILRs and all. So that is the risk you are taking. If you're generating income, etc., you may be required to give an explanation. If you ended up doing it by mistake, etc., definitely seek the advice of any immigration lawyer. We advise on these matters. We have advised in the past also where clients have done some things by mistake and we asked them to undo it. We explained it and everything went through fine. So yes, if it's a mistake, then yes, it can be rectified. You accept your mistake, you go on and do whatever there are. So whatever we can do, we will help out with that. So if you have any such case to discuss about yourself, if you already done something, definitely book a consultation with us. We can advise from there. And if you are planning to go in, this is our advice: passive directorship, passive investment. The main question that comes up is, if you are doing something, if you are doing that, whatever, how much time are you spending there? Let's say you need your, if the caseworker alleges, or if I am the caseworker, I am thinking, oh, you may be requiring maybe 20 hours a week for that. I don't think so. Or say you may need 40 hours a week to generate that income or whatever you are doing on that side. So then I have a challenge saying, how is this person working 36 hours, and then that is something you have to justify. That is what justified through the covering letters, where you get the lawyers into play and all of that. And it has always to be front loaded, which means that when any application is filed, either extension, ILR, whatever that is, everything has to be gone in upfront, rather than, because they may not give you the opportunity, and it may also be alleged saying that you have been working out of your compliance. So whatever you are not allowed to do, that you are doing that, something like that. So, and that becomes a big problem. And on tier 2 and all, it is a issue because administrative review is the only option. You will not have appeal rights and all. So there is no independent judge looking at it. It's just another caseworker looking at it. And yeah, so chances of success over there would be very low. So rather, if you've already done something, it has to be addressed properly with all explanations, evidences as to it was possible for me to work here and also there, whatever that was. It was not 40 hours, it was 5 hours, 1 hour, anything and everything. If you already done that, has to be explained properly. And because these things will come up, I'm pretty sure it will come up in their searches and they would be queried, or decisions may be made on that, on those basis, whatever they see. So it is always advisable, so they don't take it as a blanket advice: I can do this, I cannot do this. Even on these ones there may be questions. I'm not guaranteeing that a passive directorship would not come up, because they do run a company's house check, etc., and your names come up, things can be questioned, etc., decisions made on that basis, refusals being issued, anything, or even investments. I don't know what is your level of engagement in that investment. So all these things need to be done very carefully. So this is for your specific case. Definitely book a consultation with us, and then we can customize our advice accordingly. We can tell you yes and no, or 50-50, whatever that is, and you take your own call. So we can assess your case and advise you accordingly. The links will be down below to book the consultations. But overall, registering a business and all, it needs to be done very carefully. There is nothing specifically excluding you. Specifically, you are not precluded from doing all these things. So, but if you do these things, they may interfere into how are you working for your main employer. Are you really working or are you not? It's just a payroll being run. There are many things going on in the skilled worker area. Many frauds happen. Home office gets all types of issues: fraudulent skilled worker visas, fraudulent sponsors, employers, anything and everything. So yes, they have a right to ask you about this, or they have a right to refuse also if they don't believe anything that you say, or that or what they see on the systems anywhere, HMRC, company's house. So for your specific case, do book a consultation with us. uh, and this is the question I have been asked quite frequently. People holding skilled worker visas, uh, they do want to better themselves, grow, or do something else. uh, the other option would be to consider any other types of visas, global talent, etc., which would allow you to be self-employed and all, and switching in the UK is allowed. So there are other options also we can advise on, if you are considering those. And if you do like this video, do give us a thumbs up and click on the notifications icon. Subscribe to our channel, YouTube. If you're watching this on TikTok, follow us on TikTok as well. And thank you very much for watching.